The court will go back on the record on 22C7. All parties are back in the courtroom. The court took a recess for lunch. Told everyone to be back at 2:30. It's now 2:34. We are ready to get started. Ms. Oriani, before lunch, I gave you a Fifth Amendment right advisement and let you know you have the right to testify or not to testify. But that if you testify, anything you can may be used against you. If there's a criminal case filed, there's not one yet, but I'm not in charge of that. Would you like to testify?
Your Honor, at this time, since the petitioner has rested its case, the respondent requests that the TPO be dismissed due to no evidence whatsoever being given to the courts today. The petitioner can't produce one item that shows me harassing, stalking, threatening her prior to the TPO being granted. All evidence is after January 17, 2022. Also, Ms. Walsh falsely misrepresented evidence that she submitted today with regards to last night's issue and testified under oath to 2 documents being taken to her home. She submitted a picture, testified to it. According to the petitioner's own witnesses, Ms. King and Ms. Aveda, their testimony was 1 document and a picture was shown as well by Ms. King contradicting the sworn statements of their client and the evidence that was submitted when Ms. Walsh was on the stand. Petitioner failed to meet any of the requirements set forth in the TPO statutes. While the respondent understands the court's position on the issuance of a temporary restraining order based on petitioner's imaginary story with calculated lies and mistruths to obtain that temporary order, however, prior restraint of this court would be a violation of respondent's 14th Amendment rights as it pertains to the temporary restraining order part of quote-unquote a party speaking as petitioner is attempting to accomplish. Near v. Minnesota, the Supreme Court reversed that state court holding that prior restraint of the press is unconstitutional. The First Amendment protects citizens' freedom of speech from the federal government censorship. The Supreme Court used the 14th Amendment doctrine of incorporation to apply the First Amendment to the state governments. The Supreme Court responded that the relevant statute allowing prior restraint could lead to a system of complete censorship under the guise of preventing public nuisance. Therefore, petitioner's temporary protection order should not be granted and made into a permanent protection order. Respondent has absolutely had 0 issues following the temporary protection order issued by the court. Such obedience was not difficult to achieve, as the respondent has never met the petitioner in person before, not once. Respondent has never been to her home or made any plans to meet petitioner in person at her home address for any reason. Nor did Ms. Walsh testify here today to any of that. Further, respondent would not visit anybody at their home address without prior permission. Petitioner's attempts to manipulate the Colorado statute as it pertains to temporary and permanent civil protection orders to achieve her one and only goal to paralyze the respondent's First and 14th Amendment rights as a limited public figure as to a true crime on both a local and national level. Respondent is in fact a limited public figure who uses a YouTube channel to bring awareness to high-profile crime cases in connection with her nonprofit organization, Fight for a Family. Respondent's involvement with such high-profile cases and the families with those cases make her no less a limited public figure than the petitioner who holds the same First and 14th Amendment rights. So the respondent is asking for the courts to dismiss the TPO on grounds of lack of evidence.
Thank you. Do you have a response, counsel?
Your Honor, my understanding of the argument being advanced by Ms. Oriani is that she is requesting a directed verdict pursuant to Rule 350, CRCP 350, when viewed in the light most favorable to the petitioner in this case, Ms. Walsh has met her burden, and I think it's proper to deny that motion.
Under CP Rule 50, a motion for directed verdict. A party may move for a directed verdict at the close of the evidence offered by an opponent or at the close of all evidence. A party who moves for a directed verdict at the close of the evidence offered by an opponent may offer evidence in the event that the motion is not granted without having reserved the right to do so, and to the same extent if the motion had not been made. A motion for directed verdict shall state the specific ground, therefore, the order of the court granting a motion for directed verdict is effective without any assent of the jury. Well, that part doesn't even apply. At this point, I don't find that the standards set under the Rule 50 of the Rules of Civil Procedure have been met here. In the light most favorable to the proponent here, certainly there is evidence to support both the court's initial issuance of the temporary order of protection, as well as the respondent was making credibility determinations, or making a credibility argument that testimony so far has been uncontested. And with that, Ms. Oriani, did you choose to testify today or not?
That decision was going to be made. We were going to be dismissing or...
That motion was denied, and so now my question is, do you wish to testify?
I'm sorry, I didn't hear that, Your Honor. Yes, I do.
All right, come on up to the witness stand, please. Please raise your right hand. Under the penalty of perjury, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, have a seat. You may proceed.
All right, so responding here myself, I live in Columbus, Ohio. I've lived there since...
No, ma'am, I need you to testify. Whatever you're reading, you need to put away and just testify.
Okay. So I live, my name is Lana Oriani. I live in Columbus, Ohio. I've lived in Columbus, Ohio since 2013.
Excuse me, I'm sorry, Your Honor. I missed if the court swore Ms. Oriani in. I apologize.
I did.
Okay.
I lived in Ohio my whole entire life. I've been an Ohio resident. I am a mother to a 6-year-old minor child. I coach my minor child in sports, and I'm doing that. I've coached high school.
Objection, relevance.
Ms. Oriani, I just need the bare bones.
Okay. I have owned and operated a trivia company since 2008.
Objection, relevance.
Let's go ahead and start with this blogging that you're doing, okay?
Yep, in 2021, March 26, 2021, I obtained I sent my first live video for YouTube. That was after I went to and worked with the Christopher Lee Watts family to help the family obtain a lawyer.
Objection, relevance.
This is how I became a blogger.
Well, okay, move on from that. I don't necessarily, I understand that this conflict between the two of you originated with this Chris Watts case, but I declined to allow the plaintiffs to delve into the Watts case, and I'm not going to allow you to do that either. So,
I worked with the Christopher Watts family, started a YouTube channel after I launched a nonprofit organization known as Fight for a Family. It helps.
Objection, relevance.
I'm going to overrule that. Let's just speed this up a little bit, Ms. Oriani.
The reason I have a YouTube channel is to bring awareness to the nonprofit organization Fight for a Family. I had no idea who Ms. Walsh was. I never watched YouTube, never wanted to start a YouTube channel. There was extraordinarily a lot of defamation going on when I launched a nonprofit. That I needed to then launch a YouTube channel to clear my name of those mistruths, which were at the hands of the
I
Vanessa Walsh.
object to relevance.
Yeah, sustained. Okay, we've established that you're on the other end of this this fight for a family. Let's go ahead and move on. Ms. Oriani.
While I was a YouTuber in May, there was a sex scandal done against me with a bunch of creators.
I'm going to object once again regarding relevance.
Sustained.
Due to this, I had to start a mock trial, and I started gathering evidence, and that's what my episodes would show, are the people that falsely accused me.
I object to relevance.
Ms. Oriani, do you have anything to say regarding this protection order and the testimony of Ms. Walsh that you've heard?
Yeah, I don't know Ms. Walsh. I've never met Ms. Walsh. I've never met her in person. I've never threatened her. I've never threatened her family. Ms. Walsh reached out to me August 6, 2021 for help. I helped Ms. Walsh. Ms. Walsh reached out to me and asked me to be in an NDA with her. A couple different times, Ms. Walsh sent her business manager, James Angelo, to attempt to get into an NDA with me. I refused to comment. I didn't write him back.
I have sustained that objection many times, Ms. Oriani. Why do you insist on bringing up something that the court has already said was not relevant?
Well, because I was being reached out to, and according to me, I thought that James Angelo was part of Unmasked. I didn't know anything.
So I've told you it's not relevant. Why are you repeating that again and again?
Well, then it's not relevant. I'm just trying to explain my side of the story.
Well, keep in mind that we've already been at this all morning long, okay? So please provide me what testimony you think, and I will agree with you on, is relevant. I've already told you that one is not.
I've had, ever since the TPO was issued, I've had 64 lives, 6,200 hours of, 103 hours and 6,200 minutes of live material.
I object to the relevance of how much material Ms. Oriani is going to post.
I don't know if it is relevant. Ms. Oriani? I know that 103 hours, I listened to a tape where you said you were purposefully extending the hours so to run up Ms. Walsh's attorney fees.
Yeah, that was a joke. My channel is an entertainment channel as well as a true crime channel. So, like I was trying to say, I made that point by saying it was all taken out of content when you're only discussing a small part, like a small portion of something. So, I've never made any threats towards Ms. Walsh or her children or her husband. In fact, Ms. Walsh reached out to me, like I said, wanted my help. She has an associate who was accused me of leaking explicit videos. I showed her that I didn't do anything like that.
I object again to this is not relevant.
The videos that were shown today.
Hold on, there's an objection. Counsel, I don't find what a third party did is relevant, but I do think it goes to Ms. Oriani's state of mind. In fact, I find it cuts against her because it would go to her bias and motive against your client. So, Ms. Oriani, be careful about what you are saying and how it is construed by the finder of fact. Okay?
Your Honor, I flew all the way from Columbus, Ohio to Colorado to defend against false allegations that were made to me in the TPO. I came out a month ago. I'm here again. I'm here to defend against these allegations that I did not do. I allow people on my channel to talk about unmasked because they had stuff done to them. That's what my channel is known for. Those people came on my channel, they spoke, and then there was cease and desist sent out by Ms. Walsh to those people.
I'm objecting once again, and I understand the court's remarks the last time I objected. What it seems like to me is that Ms. Oriani is trying to present her justification for harassing Ms. Walsh rather than suggesting that she didn't or that there's not grounds for permanent protection order. So my objection to the irrelevance of this continues.
Well, and I find it goes to her motive, and I'm going to allow it just briefly. We are pressed for time. Like I told the parties, I've got another hearing at 3:30. Ms. Oriani, continue.
I do my channel. I let people come on, speak what they have to speak. I don't let people speak lies. I make them come with proof. Again, the stuff that Ms. Walsh put in her temporary restraining order, I am in no way threatened her. I didn't threaten her. I didn't contact her associates. They didn't reach out to anybody. I wasn't asking about her at all. I was doing live videos to uncover who the responsible parties were involved in. I had filed defamation suits out on people because of what they did to the nonprofit. And had nothing to do with Ms. Walsh. None of my content ever really had to do with Ms. Walsh. I used the @ symbol to tag multiple creators.
Ms. Oriani, let's stick with Ms. Walsh and the two of you. I don't care what you do with somebody else.
That's the thing. I don't know Ms. Walsh.
Okay. All right.
I've never met her.
And do you have anything that's relevant for today's testimony?
I have our whole conversation. I think is relevant.
Well, then, cut to the chase.
Ms. Walsh reached out to me. Ms. Walsh wanted my help. I helped Ms. Walsh when I found out that Ms. Walsh was playing both ends of the stick with things, and her workers were coming to me, her subscribers were coming to me, saying that Ms. Walsh was saying all these things about me. You can't trust her. Look at all the stuff that she said about you in the past. I had no idea that Ms. Walsh researched me 483 times between another individual and herself. I had no idea that Ms. Walsh researched me back in February of 2021. I was not a public figure then. I had no idea why Ms. Walsh would be searching me.
Your Honor, I am going to object.
And that will be sustained.
So people reached out to me because when they saw
That
that.
objection is sustained.
Okay. Well, I was backing Ms. Walsh in her channel. I was telling people to become subscribers of her channel. I had no issue with Ms. Walsh. Ms. Walsh knew and knows that there's no issue. That's why she reached out to me, because she was trying to befriend me, because I was getting close to the truth, which was that it was in fact Ms. Walsh that was searching me. And
Your Honor, I object to Ms. Oriani testifying about her perception that Ms. Walsh was searching her. It's not relevant.
I can put that in evidence. I have the exhibits.
Going to allow it again, I think it goes to her motive here.
It's going to be in the Dropbox that I sent you guys.
Please move on.
I was unaware of anything to do with Ms. Walsh. In fact, when I worked with Jamie Watts, I was under the impression that Unmasked was run by a woman named Sherry and Shannon. I didn't even know that Ms. Walsh was the person who Unmasked was incorporated with. Unmasked, I thought, was a big umbrella, as Ms. Walsh always referred to them as my team. She said, if you continue to do content about me or my channel or my team, I wasn't doing content about them. I was doing content on my own cases, and that one case was the target that happened towards me. It had nothing to do with Ms. Walsh. And I told that to Ms. Walsh, and I told Ms. Walsh, this has to do with Melissa Jade. It has nothing to do with you. Melissa Jade, and I told this to Ms. Walsh. Ms. Walsh never asked me to not contact her. I blocked Ms. Walsh. I'm only taking the stand here today because I'm floored at the lies that have happened today. I cannot believe what has happened today. I have no reason to come to Colorado. I've never been to Colorado other than one time. And then on these occasions, because I was basically issued to come here, I made no attempt to ever tell that to Ms. Walsh. I didn't even know who Ms. Walsh was. In fact, when Ms. Walsh reached out to me, I told her, I said, do you know a woman by the name of Andrea Powers? Because she's the one. And she said, yeah, she's in my Patreon group. And I was like, well, she's the one that gave me a picture. I didn't believe it was her. I didn't believe it was her husband. And that's why I put it in to see if Andrea Powers was being honest or not. That video was in a private Facebook group. And there was nothing ever said about that ever again until Ms. Walsh twisted the narrative to say that I did that as a threat. That's just unbelievable. I don't even know who it was. The picture that was given to me by a woman by the name of Andrea Powers. Then Ms. Walsh says to me, oh my gosh, that's the woman that I just kicked out of my group because Melissa Bayo, who's her team member, told her that she was a known internet troll. So she kicked her out in March of 2021. I didn't talk to Ms. Walsh until August 2021.
I do object. I understand the court's ruling, and I understand what the court is saying about motive and bias. I do want the record just to be clear, though, that I am continuing to object.
Then I'm going to, at this point, we've gone so far afield, I'm going to sustain that objection. Move on, Ms. Oriani. I don't find that testimony relevant.
Okay. I was everything that I ever said to Vanessa was to always help Vanessa. I was actually became good friends with her ex-colleague, Teresa, and Ms. Walsh was under the impression that her ex-employees who left her in October told me the truth. And I didn't know anything about it. I didn't know anything about this, about why the real reason that her staff left her. Ms. Walsh hasn't produced any content. It has nothing to do with her inability to focus or be there. Ms. Walsh kept repeating to me about, we don't give up, we don't care about Lynn and Natasha and all these creators. We're so busy making content over here. That was her repetitive messages to me.
I hesitate to say this is irrelevant because it's so incoherent. I really don't know what it's about. But
I don't either. I
guess I'm just trying to explain our relationship. There is no relationship. It was talking about content.
Then I think you've done so very distinctly. There's no relationship. All right.
I don't know her.
Is there anything further?
No.
Okay. Cross-examination?
No, thank you.
All right. You may have a seat, Ms. Oriani.
I mean, there's...
I'm going to allow each side about 5 minutes for a closing statement. Let's go ahead and start with Petitioner.
Your Honor, I want to start briefly with outlining some of the First Amendment and 14th Amendment case law that applies. There is limited case law regarding how to deal with limited public officials, and most of it is in the context of defamation, but I think it's a helpful analogy.
Okay.
You
are hard to hear. Hold that microphone. That whole thing moves over.
Sorry. McIntyre v. Jones, 194 P3rd 519, which is a Colorado Court of Appeals case from 2008.
Oh, I just got 194. What else?
194 P3rd 519, and it's a 2008 Colorado Court of Appeals case. That case breaks down the correct analysis for defamation, but I think it relates to this because what a defamation case is about is what is not protected speech under the First Amendment, and what we are dealing with here is avoiding a prior restraint that would impact protected speech. So therefore, anything that would be defamatory or not covered by the defamation laws would therefore be something that could be restrained under the First Amendment and the 14th Amendment. In McIntyre, the Court of Appeals breaks this down into a 4-part inquiry. First is that it must involve a matter of public concern, which is a case-by-case inquiry, and it embraces an issue about which information is needed or appropriate, where the public may reasonably be expected to have a legitimate interest in what is being published. It can be fairly considered as relating to any matter of political, social, or other concern. Second, for purposes of this hearing, we do acknowledge that both Ms. Oriani and Ms. Walsh are limited public figures. Whereas a public figure is one who has assumed a role of special prominence in the affairs of society, for example, a movie star or the President of the United States, a limited purpose public figure is someone who voluntarily injects himself into a particular public controversy. In this case, for example, the Watts matter or any other true crime issue that each of them is reviewing. Number 3, it has to involve an issue of constitutional fact. So whether the statement involves a matter of public concern, whether the person is a public official or a limited public figure, and whether the statement constitutes, and this is super important, a protected opinion. And so what this is aimed at doing is making sure that journalists can publish opinion pieces about even limited public figures as it relates to an individual controversy. Using this framework, we can determine that the permanent restraining order that we are seeking in this case, which we are absolutely seeking to define more clearly for Ms. Oriani, would not be violative of the First or 14th Amendment. The statements in this case about Ms. Walsh that we have talked about throughout the day today are not a matter of public concern. They are the exact opposite. They're about immensely private matters relating to miscarriage, her husband, her 14-year-old daughter. And Ms. Walsh is a person who has taken pains to not reveal her true self and not provide any information about her family online. And while she is a limited public figure, that is for purposes of a specific type of controversy that is in the true crime arena. It is not, it does not make her open game for dealing with any old thing that comes up in her personal life. Number 3, the personal information and destructive and harassing comments to Ms. Walsh broadcast, across this YouTube channel is something that Ms. Walsh has expressed concerns about, and I think those concerns are borne out today. But Ms. Oriani has a following of people who are willing to be, I think, openly dishonest in order to assist her. And when that comes to people serving papers that they understand they have no business serving just to harass her on Ms. Oriani's behalf, that is an alarming development. Most importantly, the information that Ms. Oriani is expressing on her YouTube channel are not a personal opinion. It is personal details about Ms. Walsh. It is not a personal opinion. If she was posting the absolutely obscene Shazam videos that she had talked about and discussing the Watts case, that would be something that I find abhorrent, but it would be something that is protected by the First Amendment. Disclosing someone's address, posting pictures of their husband who's a private person, and doing other things is not part of that. And so applying that analysis to the prongs the court has to determine in this case, number 1, Ms. Oriani did commit acts constituting grounds for issuance of a protection order. Nothing that Ms. Walsh testified to is controverted at all by Ms. Oriani. And in fact, I think the record is very clear that before the two even met or had anything to do with each other, Ms. Oriani was so desperate to get Ms. Walsh's attention that she posted a photo of her husband during a trailer. And that was in Exhibit 14D on 1/5/21. And then a year later, she has another video on 12/31/21 where she is admonishing Ms. Walsh for not responding when that video of her husband was posted the first time and then posted a second time. Although the court heard about a lot of different concerning behaviors tonight that can kind of broadly be categorized as content that is broadcast to a group of people that is intended to harass and intimidate Ms. Walsh by providing confidential health information, confidential information about her personal life, confidential information about her husband and child, her IP address with her zip code, her full name, and other things she has tried to keep secret. I think it all is really encapsulated well into what happened last night. And what happened last night, based on the testimony of Ms. King and Ms. Abeda, who testified contrary to one another in several respects, and I think they were taking great pains to please Ms. Oriani. They both testified that they served a document that they knew was not proper service. The court has the exhibits on 10G, 10H, showing what, and then 10A through D and 10E, that it was not one subpoena, it was 2. It included a subpoena to Ms. Oriani's 14-year-old daughter in what I think was a transparent attempt to intimidate her to not show up today, that nobody thought that was good service. Ms. King testified sort of confusingly that she didn't understand what she was doing there, and she was very reticent to say who she knew and what her job was, even though she flew here from Iowa to be present at this hearing. Ms. Abeda testified that she knew full well it wasn't good service, that she did it at Ms. Oriani's request, that Ms. Oriani had given her the documents, then advised her that they were quashed, and while they both tried to backtrack and act like they were only serving Mr. Walsh, which would have been harassing enough, they also attempted to, and I hesitate to use the word service, that is certainly not service, but they included the subpoena to Ms. Walsh's minor daughter as part of that in what is an escalation of prior threatening and harassing behavior which occurred online, and then they showed up at her house. This is someone who flew here from Iowa to do Ms. Oriani's bidding, and another person who is essentially a fan of her YouTube channel who is driving around doing her bidding. And I think that escalation really goes to the second prong, where unless restrained, Ms. Oriani is not only not going to stop, she is going to continue to escalate her intimidating and harassing behavior of Ms. Walsh, and I request that the court grant the permanent restraining order.
Counsel, on the first prong, there are certain areas that the court must find before an order of protection can be granted. And those are found at 13-14-104.5. You said you think that there are ample grounds, and you have cited reasons, but I'd like you to marry those reasons with one of those categories.
Thank you, Your Honor. I believe that this falls in the category most prominently of to prevent stalking. Under 13-14-104.5-1A, what stalking is, the way that it's defined in the Colorado Revised Statute, is sort of can be understood shorthand to be sort of the like harassing type behavior, but with the equivalent or with the addition that it is conduct that is likely to cause and does cause, or likely to cause a reasonable person emotional distress and does cause Ms. Walsh emotional distress. And in this particular case, the persistent harassing behavior, the contact, the needing to block her, and then Ms. Oriani's escalating behavior once she was blocked is absolutely harassing. It would certainly qualify as harassment under the laws of Colorado, and it is something that would cause an ordinary person to experience extreme emotional distress. And very importantly, it did cause Ms. Walsh extreme emotional distress. She testified that she was having insomnia, that she had to take additional anxiety medications, that she was distraught because her husband had to take down all of his social media because he'd become a target, and that she was experiencing very acute physical issues, including increased high blood pressure. And looking at 18-3-602, which is the definition of stalking, it says a person commits stalking if directly or indirectly the person knowingly, repeatedly follows, approaches, contacts, places under surveillance, or makes any form of communication with another person, a member of that person's immediate family, or someone with whom that person has or had a continuing relationship in a manner that would cause a reasonable person to suffer serious emotional distress and does cause that person, a member of the person's immediate family, or someone with whom that person has had a continuing relationship to suffer serious emotional distress. For purposes of this paragraph C, a victim need not show that he or she has received professional treatment or counseling to show that she suffered serious emotional distress, although Ms. Walsh did testify that she had. And one of the other elements of stalking is there has to be a credible threat. What the definition of a credible threat under that same statute is a threat, a physical action, or repeated conduct that would cause a reasonable person to be in fear for the person's safety or the safety of her immediate family, or of someone with whom the person has or had a continuing relationship. The threat need not be directly expressed if the totality of the conduct would cause a reasonable person such fear. And in this case, I believe that the totality of Ms. Oriani's conduct is a credible threat that has placed Ms. Walsh in fear. I think it constitutes stalking under 18-3-602, and I think that pursuant to 13-14-104.5, a protection order in this case is appropriate to prevent stalking.
Thank you. Ms. Oriani?
Again, the evidence that was presented here today was everything that was after this TPO was granted, and the respondent did lives about the actual TPO and how astounded I was that she would file a TPO on me and be in fear for life. Like I said, and she checked the stalking box. And the only reason that there was episodes after January 17th was due to the nature that I was served, and it was on my public broadcast, or my subscribers had to call 911 because they didn't know who was
object
at
to
the
Ms.
door.
Oriani talking about facts that are not in evidence.
Certainly. Ms. Oriani, this is the time to give a summation about what was presented. I'm not going to hear new evidence. In fact, it just, it really, as a finder of fact, it just is confusing.
I apologize, Your Honor. Again, the Colorado State statute, a person commits stalking directly or indirectly through another person makes a credible threat. I never threatened Ms. Walsh. There was no testimony here that she could prevent or that she provided that I threatened Ms. Walsh. The witnesses that testified here today said that I had nothing to do with them going there. They do not know where Ms. Walsh lives. They testified to that. I urge the courts to not let Ms. Walsh give sworn statements that are not true and that would impact another person's life to the point that they won't be able to coach their kid in Little League if there's a protection order.
These are facts, not in evidence.
They are, Ms. Oriani.
Your Honor, I don't know Ms. Walsh. Ms. Walsh had me served, and the evidence does not show that I in any way, shape, or form am a threat to Ms. Walsh. She is not in imminent danger. You're supposed to be in imminent danger. I had to fly all the way from Columbus, Ohio, over a 3-hour flight. Again, I do not know where Ms. Walsh lives. Never attempted to contact Ms. Walsh. In fact, I blocked Ms. Walsh. Ms. Walsh reached out to me. Ms. Walsh asked me to be in an NDA.
I object to Ms. Oriani testifying. These things are not in evidence.
They are not.
Ms. Walsh's TPO was sent to the address that wasn't mine.
Objection, that's not in evidence.
Ms. Oriani, summation is just to highlight what has been admitted into evidence, and then you apply the elements of what you are here for. In this case, the elements of the temporary order of protection to what was actually presented.
Yes, and the evidence that was presented here has nothing to do with anything prior to January 17th. There is no grounds that Ms. Walsh should have ever filed the temporary restraining order. There was no evidence that was presented here today for Ms. Walsh asking for a temporary restraining order. It should have never even happened. Ms. Walsh was dishonest with her testimony and her paperwork. I urge the courts not to allow somebody to manipulate state statute and for a quick and Ms. Walsh simply did not like what I was talking about. It had nothing to do with her personal medical files. There's no evidence of that.
I object to Ms. Oriani talking about things that were not admitted into evidence.
You know, as a professional finder of fact, I have got pages and pages and pages of notes. So your objection is noted for the record, but we just need to get done. Go ahead, Ms. Oriani. Finish up.
Yeah, Ms. Walsh has not met any of the elements of the crime of stalking that she checked off. Ms. Oriani had nothing to do with advising anyone to go to Ms. Walsh's home. In fact, I agree with counsel. You're both limited public figures. Again, nothing is in evidence prior to January 17th, 2022. Not a shred of evidence to support Ms. Walsh's claims. Ms. Oriani has never contacted Mrs. Walsh's home residence phone. No evidence of that. No evidence of, no pictures of Ms. Oriani outside the house. No pictures of Ms. Oriani anywhere near Ms. Walsh. No direct threats. There's no reason for Ms. Oriani to do anything like that. And that's why it never happened.
Right, thank you. All right. It is now 3:20 and the court has a very brief matter set at 3:30. And then I'm going to go ahead and finish my notes before issuing my findings. I'm going to be in recess until 4 o'clock.